Thanks for joining us for the Maryland Realtors 2018 Professional Standards Training. I am Kathleen D'Artez.
And I am Colette Massengale, and we are very happy to be with you today to conduct the 2018 Professional Standards Training.
I think most of you know Colette and I, we go out and teach a lot. I wanted to make sure everyone knows everyone else in the legal department who's involved with professional standards. Jeff Bernstein is the most recent addition to the department. He's an attorney. He's been with us only for about a month, but he has already completed the Professional Standards Administrator training, so he can be a good resource for you. He has a good litigation background, so a lot of the things that processes that occur in litigation sort of translate into processes in the professional standards track as well. So he's a good source of information. Don Martin, I believe everyone knows Don Martin. He's been involved in every level of membership and has focused on professional standards for a number of years here at the state level, and he's also participated in the Professional Standards Committee at the national level as well. So Don is a good resource as well if you have questions about a process or a procedure or how to handle a particular situation. Nicole Mack, I think most of you know as well. Nicole Mack is our legal assistant in the legal department, and she also is a professional standards administrator. She's completed the training for that. Nicole probably would be your first point of contact if you had a question here at the association, because Nicole can probably answer 90% of the questions. So she's a good resource for you guys. And I just want to point out as well, as everyone knows, I believe, that we do the legal hotline Mondays, Wednesdays, and Fridays from 10 to noon and 2 to 4, or people can submit questions online at mdrealtor.org. So if for some reason you can't catch one of us, you can always submit a question through the legal hotline or online. All right, so what we're going to cover for today, these are our topics or our agenda. We're going to start with the basics, kind of an overview of what the professional standards process is and why we do it. We are going to spend some time discussing due process. Colette's going to talk about that. That really is the key for the whole day. That's really the basis for all of this. The members need to receive the benefit of due process, meaning the proper process, the process the National Association has approved, what's outlined in the manual. And if that does not happen, there are consequences. So due process is really the key. We'll briefly discuss the structure of the Code of Ethics and also alternative dispute resolution. We're going to discuss the Ombudsman program, mediation, and the citation system, which is a local board option that only one of our local boards has adopted so far, but we'll spend at least a little time discussing it. It might be something that your board wants to look into or may want to adopt. We're going to discuss also, I think Colette's going to discuss some of the 2018 changes to the Code of Ethics and Arbitration Manual, which will be a relatively quick conversation because they weren't really substantive this year. And then we'll spend some more time, I guess, talking about the role of the Grievance Committee and the hearing panel, both with ethics and arbitration. And for arbitration especially, a large focus of the hearing panel, a large part of the focus is procuring cause and determining procuring cause and some of the factors that are relevant there. So Colette's going to spend a lot of time talking about procuring cause. And we are going to conclude with the role of the Board of Directors. And the role of the Board of Directors are involved with reviewing some of the decisions, hearing appeals, and also sort of a risk management function, keeping an eye on liability and exposure for the board and trying to minimize that wherever possible. So that is the agenda for today. I guess let's get started.
Yeah, I'll just add, there will be, in addition to this recording being available for you whenever you need it, we'll be posting it to the website. There will also be some accompanying handouts, and most of the handouts are charts and diagrams that kind of give you a visual of the processes that we'll be talking about. So I think they'll be really helpful, and again, you'll be able to download those charts and graphs and things and diagrams from the Maryland Realtors website.
Good, thanks. All right, every association is responsible for enforcing the Code of Ethics. Why is that? I mean, basically, the Code of Ethics is what distinguishes realtors, all of us, from people who merely have a license. And membership in the organization, membership in the association is a valuable property right. So anything that's going to limit that or any discipline that would affect that membership, obviously it would have to be justified substantively, meaning, based on the facts, based on what actually happened, and also procedurally. And that kind of ties back to the due process concept. We need to make sure if a member is going to be disciplined, reprimanded, sanctioned, have to take a class, whatever, we need to ensure, all of us need to ensure that the proper process was followed, the procedures were followed. Failure to provide due process or failure to follow the procedures or failure to impose appropriate discipline could result in the decision being reversed, but also could expose your association to risk and to liability. So again, you've got to keep that in mind, and that's another reason to follow the rules, follow the procedures.
Yeah, and I'll just say one of the charts that you'll have access to is the Board of Directors chart, which is really, really helpful and does a wonderful job summarizing how the Board of Directors protects the association of the board from liability.
Good. Again, this part of that, thinking about risk management and limiting exposure or liability of the board. The goal is basically to avoid litigation, and that's meaning the association, really. How do you avoid getting into trouble as an association, as a board? Well, follow the rules. That'll help. Yeah. Follow the established procedures. Maintain your records as well. You want to be able to document what happened, when it happened, why it happened. The phrase in the parentheses is important as well. Your record should be in a secure location with limited access. Keep in mind, again, just out of respect for the parties, if someone is going to be disciplined or sanctioned, that is a confidential matter. You don't want to have those records, sitting around on the front desk so anyone who walks in can see that so-and-so had to pay a $5,000 fine. You really want to, like I said, respect the people, respect the process. That should be in a secure location, and only the people who need to have access should have access to that. And again, the final point here, you want to keep your local board counsel in the loop. If there's a situation that is complicated or becoming heated, or you're not certain how to respond to a particular situation, the best advice, again, would be to consult with your local board counsel, and they can guide you. Get it in writing. They can guide you, and then relying on the advice of counsel would provide a level of protection if a lawsuit were to take place. The role of staff is, I guess, also important to keep in mind as well. At your local board, you might call it the AE or the CEO, whatever title you use, is going to be involved in the process. Each local board also has someone, it may be the AE, maybe someone else, who's taken the Professional Standards Administrator training and has completed that. And that person is really going to be the point person or the primary resource person for your grievance committee, your professional standards committee, your president, your board of directors, to rely on with respect to the administrative function of any hearing or mediation. And really, that's going to be an important person. And, you need to make sure that your committees are aware that who that person is and who their contact person is or their resource person if they have any questions.
Great.
All right. The role of the association counsel or board counsel, that's your outside counsel. It's not us at the association. Again, this is your local board counsel. Their role is to protect your association because you're the client, right? That attorney is representing you, your local board. You are their client. They're trying to protect your best interest. That local board counsel is not a prosecutor. They're not coming in to prosecute a criminal. They're not going to lock anybody up, put anybody in jail. That's really not the role of your local board counsel. Your counsel does not write the ethics hearing decisions. The hearing panel would write the decision. Your local counsel, though, would review the decision, the ethics hearing panel's decision, before it will be sent out to the parties. Your counsel would review it to make sure it's legally sufficient, that the discipline is appropriate, whatever it might be. Findings of fact,
right, are sufficiently detailed.
Right. We'll talk about that later on in more detail. But yeah, that's going to be an important part of the process. And obviously, you want to review it before you send it out to the parties. So that would be appropriate for your local board counsel to provide that function. And also, your local counsel would provide legal advice when requested. An easy example of this, we'll talk about this later in the presentation. Throughout the manual, there are certain options that a local board can choose to implement or choose not to implement. And if you discuss that with us here at the association, we can explain what the options are. You know, this is how this works, this is how the other one works. But we can't really tell you, yes, you should adopt this, or no, you should not adopt this. So that would be something that you would want to discuss with your local board counsel, and they could give you better guidance on whether, you know, whether it might make sense for your board or not. And again, as you all know, just geographically, something that works very well in Montgomery County with GCAR might not work as well in historic Highlands or Cecil County. So your local board counsel would maybe have more guidance or be able to provide some guidance on those type of issues.
Yeah, and as we go through the training, any areas where we see that it's potentially you would need to seek out legal advice, we'll kind of highlight that.
Good.
Yeah. So it's Colette again. I just want to talk a little bit about the importance of due process in this context. And you'll hear us throw around that term throughout the training, because that really is the key, as Kathleen already mentioned. You know, so we say the process should be uniform, in accordance with the manual. As you probably know, for those of you who've been sitting on the Grievance Committee and Special Standards Committee for some time now, the manual is pretty extensive. And if there is a question that you have or you're not sure about, it's likely going to be in the manual. And if it's not, you can always, you know, reach out to us. But making sure that you're using this process or doing this process in accordance with the manual, so it should be uniform and reasonable. For example, as Kathleen pointed out earlier, if you determine that a realtor at your board has been found to violate one of the articles, the penalty should be reasonable, and the process should be reasonable throughout. But that's just an example of reasonableness. So throughout in all aspects of the process, and then fair enforcement, essentially meaning that anybody that comes before you, whether it's another realtor member or a member of the public, is going to be treated fairly. The same rules will apply to each and every person that comes before you. So uniform, reasonable, and fair enforcement is the key to minimizing the board's or association's liability. So what are the elements of a member's basic right to due process? Let's talk a little bit about that. We've broken that sort of concept down into some key elements. So here they are. Number one, notice of the charges. So respondent, if somebody is alleging that a member has violated one of the articles of the ADR Code of Ethics, then that person has a right to have notice of what those allegations are. And a reasonable amount of time to prepare their response or their defense. So notice of the charges is important and key element of due process. Also adequate time. So it's not just time to prepare, but adequate, sufficient time to prepare a defense. The respondent will have the right to representation. And we'll talk about the different examples of when you have right to legal counsel versus when you have right to realtor counsel. The process, there should be a full and fair hearing before an impartial tribunal. If there's any kind of appearance of impropriety or the bias or anything like that, the chairperson needs to take action, as we want to make sure, again, that the process is fair, and that all the panel members, whether on the hearing panel, arbitration panel, or on the grievance committee, are able to look at the information in a fair and objective way. Kathleen will touch on appropriate authorized sanctions. So, for example, if, again, you know, the board, let's say the ethics hearing panel determined that a realtor violated one of the articles, could the panel impose or, you know, say you take their license? That's not an authorized sanction. So you need to be aware of what the appropriate and authorized sanctions are. And in fact, there are several pages of guidelines to help assist you in arriving at a penalty that is reasonable. So we'll touch on that in a little bit more detail later. And then we'll also, the key last element is the availability of an appeal. So there are different parts of the process where a person is entitled to appeal. Both the complainant and the respondent have certain appeal rights, and we will cover those in detail in this training. Do you want to add anything?
No, I think that's good.
Okay. So we talk about due process and the right to representation. What does that mean? So the right to representation means that each party, whether you're a complainant or respondent, can be represented by legal counsel. So legal counsel can advise them on, evidence, presentation, witnesses, documents, any and everything, any aspect of the process. Either party can be represented by legal counsel. Now, realtor counsel is only allowed in ethics hearing, in an ethics hearing. So if a complainant or respondent wanted to have their office manager or their broker assist them in this process at the hearing, then they would be able to do that in an ethics scenario.
I would just add to that, the realtor counsel, just keep in mind if it's your office manager or broker, if they are acting in the role as your realtor counsel, remember that an attorney can't testify, cannot be a witness. So if they're acting as your realtor counsel, they cannot also be a witness for you. So keep that in mind. If the person's office manager has specific knowledge about the situation, the office manager maybe should not serve as realtor counsel because they may be more appropriately be a witness for the situation. So
yeah, that's an excellent point, and definitely something to keep in mind.
Yeah.
All right, so moving forward, what does before an impartial tribunal actually mean? So what it means is no kinship or business relationship. There are automatic strikes that happen to deal with that. And then the parties also have an opportunity. Once the list of panel members is constructed, they will have an opportunity to go through that list and see if there's anybody on that list that they feel would not be able to make an impartial decision. So that's important in terms of making sure that the people that are going to be hearing the case, whether it's ethics or arbitration, are of the mind to be objective and impartial. Want to add anything to that? No? All right. So strikes by either party, and then the panelists must give impartial consideration. So that's really it in a nutshell. You have to look at the situation, the facts, or the allegations, and be able to make an objective decision based on the evidence that's being presented. All right, so due process, the hearing panel chair should make sure no panel member has a conflict of interest or cannot be impartial. If the chairperson, they have complete authority. If anything arises that would suggest that that person cannot be impartial or there's some kind of conflict of interest, then they really have the duty to ask that person to step down, because that will compromise the hearing. And if there is these suggestion or hint that that person can't be impartial, that could trigger an appeal from either party. So you definitely want to deal with that situation immediately if something like that arises. All right, so we'll leave that there for now, and we will just discuss briefly what the structure of the code is. In the handouts that we put together, there is sort of a kind of a quick and dirty list of the various articles. They are broken down similarly to how the Maryland Code of Ethics is broken down. So you have Articles 1 through 9, which are realtors' duties to clients and customers. And we know at the very first article is to protect, responsibility of realtors is to protect and promote the client's interests and to be honest. So Articles 1 through 9 deal with your duties as a realtor to clients and customers. And then we go on to Articles 10 through 14, outline your duties to the public and include things like providing equal and fair services, being knowledgeable about what you're doing. So for example, if you typically, service Anne Arundel County, then you have a duty to, and if you, let's say you want to, have a listing in, Montgomery County, then it's your responsibility to become knowledgeable and educate yourself about what the rules are for that particular area so that you don't come into an issue with Article 11.
Or make a referral.
Or, yeah, you could
I just throw that in.
You could absolutely make a referral, and that's absolutely true. And then the third category of obligations are Articles 15 through 17, which deal with your duties to other realtors. And I would say, Kathleen, you can chime in too, typically what we tend to see more often than not are issues surrounding Article 16, which requires that you respect the exclusive representation or exclusive brokerage relationship agreements that other realtors have with their clients.
I would agree.
Yeah, so that's really a one, Article 16 is one to look out for. But that's just your kind of basic structure of the code. Did you want to add anything, Catherine?
No, I think we're good.
Okay. So now we'll talk a little bit about the standards of practice. So the question really is, you know, we talked about the articles. There are 17 of them. Can a realtor be found to have violated a standard of practice? What is a standard of practice? So the answer to the question is no. A realtor can only be found in violation of an article. The standards of practice are used to amplify, explain, and interpret the principles behind the articles. So, for example, if you've got, if a complainant wants to say, hey, you know, this realtor over here violated Article 16, then perhaps they might use, you know, standard of practice, you know, 16-7 in support of their allegation or their claim that Article 16 was violated. So a realtor cannot be found to have violated a standard of practice. They are there to interpret, explain, and support the principles behind the articles. So you must, the allegation must cite an article. Standard of practice can be cited in support of an alleged violation of a particular article. So not only can the complainant use the standards of practice in support of their allegation, the hearing panel, an ethics hearing panel, can use the standards of practice in trying to figure out or determine whether or not a violation has actually occurred. So they can be used in two different ways. Both deal with explaining, amplifying, and interpreting the articles. Did you want to add anything to that?
No, that's good.
All right, so that's the standard of practice. What about the case interpretations? So for many years, the case interpretations used to be actually the last section of the manual. In the 2018 version of the manual, the case interpretations have been removed. So if you want to look at a case interpretation, you will need to go to the National Association of Realtors website. All you have to do is type in the search box case interpretations, and you will see all of them. There are at least, I don't know, 50 to 100. There are many under each article. What do? They explain, they amplify. It's similar to what the standard of practice do. Standards of practice do, they amplify, explain, and interpret the principles behind the articles. They illustrate specific examples. So basically what you will see with the case interpretations, which is different from the standards of practice, the case interpretations are fact patterns. So they will show you, you will see a set of facts, and then you will see sort of an analysis of those facts, and it'll explain how the hearing panel, looking at those facts, arrived at their decision. So that's kind of the difference between the case interpretations and the standards of practice. The case interpretations are fact patterns with sort of analysis of what that fact pattern looks like against what the articles say, and then the hearing panel deciding whether or not a violation has actually occurred and kind of giving you a rationale for their decision. Anything you want to add there?
I was just going to say, I think, personally, I think the case interpretations can be very helpful. It does give you maybe a little bit of a more nuanced understanding of what the article means or how it actually is played out in the real world. And, you know, whether some document existed or didn't exist could mean the difference between whether Realtor A prevails and you know, is found not to have violated the article, or whether they are found in violation. So they're really helpful, especially if you're maybe a newer member of the committee. I would suggest you take a look at the case interpretation.
Yeah, they are, and we actually use them. So, you know, when we go out and teach Code of Ethics, we sometimes will borrow one of the case interpretations, remove the hearing panel's analysis, and see, you know, what folks think about what that particular fact pattern says and whether or not there's a violation. So they're very, very useful tool for helping to explain and interpret the articles. So the next point I want to just talk about just briefly is what do we mean by making it your own? So if you go to page I of the 2018 manual, you will see a hand icon, maybe in the middle of the page or the first column. What that hand icon means is that your board or association needs to make a decision about a particular action. So for example, the board of directors would need to decide whether or not to allow the the parties to record the hearing. So there are, I don't know, maybe 2 or 3 pages of various decisions that the board of directors would need to make. And we believe that it's a best practice to go over these decisions every year. You may find that you want to change them. There may be some new ones added. So it's always a good idea, as soon as the manual comes out, for the board of directors to sit down and go through the hand-icon section to make sure that they want to maintain whatever decisions they previously made or change any decisions, and then, of course, address any new decisions that may have been added to the manual.
All right, I guess back to me again. Our next segment, we're going to discuss alternative dispute resolution, ombudsman services, and mediation. Again, we have offered training previously for ombudsman services. I'm not sure if everyone's familiar with what that is. The National Association of Realtors rolled out its ombudsman program 2-3 years ago now, I think it was. And each of the local boards has, I believe each of the local boards participate in the training that we offered here at the state level. So all of your local boards should have a panel, or at least a small group of people who have members, realtor members, who have been trained to serve as ombudsmen. So what this is basically it's an informal dispute resolution process. If someone calls your local association or your board, let's just say it's a client who's unhappy with something, they don't like something. Honestly, one example in the real world, the realtor ran over their mailbox and knocked their mailbox over to the ground, and they're quite upset about this. It's happened quite a few times. I've mentioned that in class and been surprised at the number of times that heads nod and people say, oh yes, that can happen. So anyway, so this person's very upset and they're angry at this realtor who's working with the people across the street or whatever it is, and they want vengeance is the first word that pops into mind. That might not be appropriate, but when they first make the call, they may want vengeance. So that type of thing, if the person who's answering the call at your local board, we want to address the situation to calm the person down, give them whatever, may hopefully not vengeance, but address the situation and calm them down and resolve the dispute. So what the local board, whoever's answering the phone, can make the angry person aware that one of the services the local board can provide is ombudsman services to kind of resolve this dispute. And if the angry person would like, you can refer that person to one of your trained ombudsmen. And the ombudsman will call the person and speak with the person on the phone. For the most part, this is all done on the phone. And find out what the situation is, what happened, what the complaint is. I'm very angry that, this realtor whose sign is plastered all over the side of her truck, I know who she is, and she knocked my mailbox over, and I'm very upset. So the trained ombudsman can get all the facts and then ask the person, would you object to me calling the realtor and discussing this with the realtor? Typically the person would say, yes, of course, call the realtor. So the ombudsman could then call the realtor and find out what happened. I don't know if you realize it or not, you knocked this person's mailbox over, they're quite upset. Is there something we can do here? The realtor could maybe say, yes, I'll have a handyman come, I'll give a gift card from Lowe's, I'll do or Home Depot, whatever it might be. But the ombuds person could be involved in that process, talk to both parties, and see if there's something they can work out informally. Sometimes a person might just need to vent, they might just want an apology, whatever it is. Yeah. But the ombuds training gives the participants some tools and some options and ways to phrase things and kind of to de-escalate the person's anger sometimes. And once you de-escalate, then you're obviously closer to getting a resolution. So that's basically what the ombuds process is. This slide discusses all of the options, sort of the least formal to the most formal. The ombudsman process is the least formal. That, honestly, the easiest way to think of it is a telephone mediation. Right. The ombuds person is basically acting as the mediator and helping the parties to come to a solution that they both can agree to. The ombuds process, or the program, the only information that is kept is really just numbers, how many people called in, how many matters were referred to an ombudsman, and were they resolved or concluded successfully. That's really all the information that is tracked. Other than that, the Ombudsman, they shred their notes. They don't keep written records. There's no formal decision that's written. That's really all that happens. And anything that is said or takes place during that process, it's not going to be referred to any other committee or move forward in the process. It really is separate and apart. We've done training here. If you are interested in that and have not completed the training, you know, pay attention. We do offer that training periodically, and we've heard good reports back from people about the success of the program. A lot of the disputes, I don't know a percentage, but a lot of the disputes are resolved successfully. And again, keep in mind, part of the goal here, we don't want people filing complaints. You know, if someone can call in and be unhappy with something or angry, and we're able to talk them down, de-escalate, get them to accept something as simple as an apology or whatever it might be, then that person's probably not going to file a complaint, and that respondent, that agent, that member will not have a complaint filed against them. So this is really the ideal way to resolve it, if at all possible. The next step up in that inverse pyramid up there, so the next most formal step would be mediation. Slightly more formal than the Ombudsman. Again, a mediation is going to be, it's going to take place in a room. It will be a face-to-face meeting. One person acts as the mediator, and again, mediators have to complete training in order to be qualified to serve as a mediator. Each of the parties will meet with the mediator in a room, and this is considered, I guess, not quite as formal as some of the other processes, because the mediator doesn't actually make the decision. The mediator is going to assist or facilitate the process and help the parties come to a decision, but the mediator doesn't say, here's what's going to happen. So that's not as formal as the other ones on the pyramid. Arbitration and ethics are the next step up, I guess, in increasing formality, and they are more formal because there actually is a hearing held. There's typically a panel. There will be evidence. There'll be documents that's submitted, and there will be a decision made. Again, with ethics, it'll be written. Arbitration, it won't. But that's a more formal process than what has happened the first two steps. The next step up for increasing formality is the Maryland Real Estate Commission. Again, remember Colette earlier had talked about appropriate discipline, inappropriate discipline. We can't suspend someone's license. The local board, the state association, we don't suspend people's licenses. The Real Estate Commission is who grants licenses, who can discipline someone or suspend someone, revoke someone's license. So that is a formal process. There are processes put forth in the Maryland Code of Regulations that govern timeframes, and if that goes all the way through, the parties could end up in front of an administrative law judge. So that's relatively formal process. They are at the very tip of the pyramid on this chart is court or litigation. Obviously, that is the most formal process. There are very specific rules and regulations in court. There are timeframes. There are rules of civil procedure. Parties are only entitled to certain things, certain remedies, whatever it is. So that clearly is the most formal process, dispute resolution process.
Yeah, and the only thing I would add to that is I think if at all possible, you want to avoid court.
Oh, yeah.
I mean, if like Kathleen said, if the issue or the money dispute or whatever it is can be resolved in one of these less formal venues, then I think that's where you want to go, because court is, bottom line, court is very expensive to litigate. Right. Very expensive to litigate.
And time consuming.
Exactly. And it could take, 1 to 2 years to get something to a resolution in court. So.
Right. All right. So what is the Realtor Ombudsman? I went into this a little bit already as I was going through my pyramid there. The Ombudsman, as we had said, is basically a peer, meaning a Realtor Ombudsman. There's going to be a member, someone who is actually a realtor, mediator working by telephone to resolve disputes. The Ombudsman program, again, like I said, we've had great success with it and heard very positive feedback on it. Partially, I guess, the public perception of the whole grievance process and professional standards and filing a complaint against a realtor, the perception would be that it's cumbersome. It's a long process. I have to fill out all these forms. I have to take a day off work. I have to go to a hearing. Yeah. That's a little bit off-putting for most people. Especially if someone's like at that sort of ratcheted up anxiety level, they may really just want to vent and get the solution, their issue resolved. They don't want to spend a year on this or 6 months on this, So the Ombudsman program would really be appropriate for those kind of situations. If I can just resolve, I can speak with somebody on the phone, let them know what my concerns are. They're going to talk to the other party. We're going to work it out. That, I think, is really the ideal solution for a large number of disputes, and certainly for members of the public. Also, just the final point there, public perception, that last point, may feel the association is protecting its own. That is true, I think, sometimes even within a brokerage. If a client is unhappy with something their agent has done, if they call and speak to the broker or the office manager, they may feel that the broker or office manager is just going to cover for the agent. You know, if they say the agent did nothing wrong, well, sure, they're just covering for their people. You know, the consumer, the client, may not feel like they're getting a fair shake. So I think if that's the perception or the way the public perceives it, then the Ombudsman program obviously would help resolve that issue, because it's a neutral third party. It's not the broker. It's not the office manager. It's probably not even going to be someone from that company. It would be a neutral third party hearing the complaint and addressing the complaint. And the final point down here, maybe Colette, maybe next year we'll put this as the first point. It's required. You have to have an Ombudsman program. So there actually are real tangible benefits to it, but it's also required. You have to have it now as an association. The benefits here, kind of touched on these a little bit as well. Provide enhanced communications. Again, if you're a realtor and you've been in the business for a while, it's surprising sometimes how many issues or problems come up because of poor communications. And once you get to that stage where communications become poor, oftentimes it really is hard to move beyond that. If the parties are angry or agitated, not working together well for whatever reason, it can be difficult to move forward. So the Ombudsman process, again, is a way to get around that or beyond that, hopefully. The angry person, the agitated person, can speak with an Ombudsman who's been trained kind of to de-escalate and help the parties work toward a resolution, and they can move forward, hopefully, to a successful resolution of the dispute and possibly the transaction. The other thing, again, your story being heard, someone cares and listens, that really is important, especially to the consumer. If they feel like, you know, people are protecting their own or whatever, it's important for them to feel that they've been treated fairly, someone has listened to them and addressing their concerns. And again, similar to what Colette had pointed out with litigation, the Ombudsman, ideally, this is going to be a quick process. It's going to be a couple phone calls, hopefully, and the issue will be resolved. Hopefully they're not going to file a complaint. There won't be a hearing. They're not going to, it's not going to be a very involved, convoluted thing and take up everyone's time. So there really are a lot of tangible benefits to the program and for the, for the parties and for the members as well. Yeah. The role of the Ombudsman, again, like I said, similar to mediation, the Ombudsman does not determine what the outcome is. The Ombudsman doesn't say, well, here's what's going to happen. You're going to calm down and you're going to shut up. That's not, you're going to go away and you're going to like it. That's not what happens. The Ombudsman, they communicate and they act as a conciliator to try and bring the parties together to something that works for both of them. The Ombudsman doesn't determine whether the agent or either party basically has engaged in an ethical violation, whether an ethical violation has taken place. The attempt is to, again, as we said earlier, resolve disputes before things escalate, so the parties will not end up filing a complaint or entering into the professional standards process. And again, the Ombudsman is not going to determine who gets the commission. That's not the role of the Ombudsman either. That's going to be, you would have to go down the arbitration route for that. Okay. All right, the filing deadlines, I guess this is important. We'll talk about some of these deadlines later on in the program, the presentation, but the 180-day filing deadline, typically you would have 180 days from, well, we'll go through that later. But if someone engages in or participates in the Ombudsman process, it doesn't negatively affect that 180 days. The 180-day period would be told or stayed or paused would be a good way to think about that while the Ombuds process is taking place. So if the Ombuds process takes 10 days, they would have 180 days plus 10 to file. That's basically how that works. It's suspended, I guess is the word we have here on the slide. So the suspension, the time that would be suspended would be beginning from when the person requested to use the Ombuds services, and it would pick back up again, or the time frame would kick back in, I guess, when the Ombuds process is concluded or ended. Right? And if you have any questions about this, about the time frame, about the dates, obviously you would check with your check with the association, with the president or someone they've designated. They can clarify what the time frame was for you. All right, mediation. Let's keep going with mediation. Again, remember back to the inverted pyramid. Mediation was the Second from the top, meaning still relatively less formal process. And this is in the realtor context, I guess, and outside of the realtor context as well. Remember, in the contract of sale, if there's a dispute between the buyer and the seller, they're required to go to mediation first before going to litigation. So the general concepts would apply in both situations. Here for us, mediation, the key features of the process. In general, it's voluntary. One of the local board decisions that's in the manual, I can talk about this later. Your board can make mediation mandatory. That's an option, a decision that you may or may not select, may or may not choose to do. But in general, it would be voluntary. So the parties are going to decide, yes, we want to try mediation to attempt to resolve this dispute. The parties can end it at any time if they decide they change their mind. This is hopeless, you know, this jerk's I'm never going to be able to work with this jerk. This is not going to work. So they can terminate the process at any time. And one of the key features, again, is the parties decide on what the outcome is. The mediator doesn't say, well, you're going to do this for them, or you're going to pay them this or that or the other. The parties decide what works for them, what they can accept, what they can agree to. That's why it's a relatively less formal. There really is not an adjudicator. It's really a judge or adjudicator. It really is a facilitator to help the parties come together. The advantages of mediation, or why mediation works, it's quick, again, especially compared to litigation, which can go on for a long, long time. Low cost, again, there's all kinds of filing fees and some of these other process. Mediation generally would not incur that, or relatively low cost, again, particularly compared to litigation. Flexible process, that is probably the key right there. It is a flexible process. Whatever the parties can agree to can be the solution. Right. It doesn't have to be something that would happen in court, like maybe a written apology. Typically a judge is not going to tell someone to apologize in writing to someone, but if that's what it takes to make someone happy, if the party asks for that in a mediation, I just really want this person to recognize that what they did is wrong, and I would like them to apologize to me in writing. If the other party is willing to do that, then they are happy, their matter is concluded, and they've reached a solution. Again, the thought here, again, is that would maintain and improve relationships as well. Kind of goes together. If you're spending less time on the dispute and resolving it more quickly, ideally that would maintain your relationship. And getting the parties to come together and talk, that's important. And I think maybe something for all of us to keep in mind now with social media and all of these emails, especially in business, it's really easy to get very emotional and angry and dramatic in emails and in writing. And sometimes people will say awful things or inappropriate things in an email. They're going back and forth, or text, for God's sakes. But often if you get people in the same room, sitting down at a table across from each other, eyeball to eyeball, it does de-escalate. And generally, hopefully, they're able to communicate in a rational manner and kind of get rid of some of that drama and some of the emotion, and maybe be able to speak, I felt like you weren't paying attention to me, or you weren't, responding properly when this happened. That might be a way to address that and communicate it face to face, and hopefully they'll be able to reach a resolution that way rather than just increasingly angry emails back and forth. All right, the next slide is why mediation works. Again, kind of a continuance of the previous slide. Improving poor communication, resolving a misunderstanding. Again, that sometimes can happen with emails. Right. It might be apples and oranges and you don't even realize it. One party can be talking about one thing, the other person may not be even responding to that issue, but still can escalate the situation. So face-to-face often can resolve those type of situations. The second point here, discover and address the true interest of the parties. That is important. That can be the role, or that actually is the role of the mediator. Right. And oftentimes what would happen, the mediator would meet with both parties initially, and then the mediator typically would send one of the parties out of the room and meet directly with the other party in the room. And that's where the mediator can find out what really are you looking for, what will make you happy. And sometimes the mediator, especially I know in court situations, the mediator could say, well, here are the strengths of your position, but there are some challenges that you have as well, kind of maybe make the person sort of think about reality a little bit. And then typically the mediator would send that party out, bring the other party back into the room and have the same conversation with the second party, figure out what it would take to make them happy, what they'll accept, what their real goal is, what they must have. And again, then the mediator would bring both parties back in and hopefully be able to facilitate them and get them to a resolution where they both can move beyond their initial position and get them to a creative solution. And hopefully the dispute will settle.
Yeah, I mean, I'll say one more thing about that. If the parties hopefully they do arrive at whatever the creative solution is, it would be reduced to writing. And they would, that would be the agreement. But as Kathleen said, the wonderful thing about it is that they have come to that resolution and agreement together. It's not some third party telling them this is what's going to happen. So they've reached that agreement together.
Good. That's a good point. Thank you. All right. So we are going to talk next. This is going to be relatively brief. The citation system. That is a local board option where you can choose to implement a citation system, or you can choose not to. It will be something, again, your local board would decide. Maybe you want to talk to your counsel about it. In Maryland, GCAR has adopted the citation system. I know the Northern Virginia Association of Realtors has also adopted it. One of the items that's in the handout is a citation, a policy decision tree. It sort of walks you through the process. I'll just kind of go through this very quickly. Basically, a complaint will be received at your local board or association. The complaint will be forwarded to the grievance committee, following typical procedures. The grievance committee would look at it to determine if there's a potential violation, assuming all the allegations are true. Again, typical process right up to this point. So now then the grievance committee is going to say, if there is a potential violation, is this conduct the type that is covered by the citation schedule? If yes, then the committee would again look and say, are all of the violations subject to the citation schedule? So they would have to be, appropriate for the citation program, and all of the violations, if there's multiple violations, all of them have to be subject to the citation schedule. If there are multiple violations, but they are not all subject to the citation schedule, then the matter would be back on the regular track for professional standards hearing. So if there are potential violations that are of the type prohibited under the citation system or covered under the citation schedule, then we're bumping down another level. The complaint and the citation schedule are sent to the violator, to the respondent, the person who, committed the wrongdoing, with a copy to their designated realtor. And then the person has 10 days to comply with the terms of the citation system. Basically, it's going to be paying a fine. And they're either going to comply or contest it. And then I guess at that point, the complaint can be sent back to the grievance committee if they're going to contest it. And if they, if they contest the citation, they object to it, they don't want to do that, then the complaint goes back to the ethics hearing panel. So basically, it's a way they can acknowledge wrongdoing and pay a fine. If they don't acknowledge it, or if it's not something that's appropriate on the schedule, then it does end up on the normal path, on the normal track. Like I said, GCAR has adopted this citation schedule already. If your local board is thinking about it, you might want to reach out to GCAR, maybe Mike Moran or Yvette Robinson at GCAR to discuss particulars with them, or Colette and I here, we could help you with that too. The Northern Virginia Association has adopted it as well. One concern that I have heard from people in general is that if we adopt a citation system, then these people who are engaged in wrongdoing, they're going to keep doing what they're doing. They're just going to write a check for $100 every once in a while, or write a check for $200 and keep doing what they're doing. And just to address that, the way the programs are typically set up, that really would not occur. GCAR has information on their website that you can take a look at if you want, but this is based on the NAR model citation schedule. GCAR increases the fines if someone does it again. Frequent offenders are fined a larger amount. So for the first citation, the fine would be whatever is listed. It might be, $250 or $500 for whatever it is. Let me see one. Standard of Practice 1-6. Realtors shall submit offers and counteroffers objectively and as quickly as possible. Failure to do that is a $500 fine. So if someone acknowledges something happened, they did not, submit the offer and counteroffer quickly, they can acknowledge wrongdoing, pay the $500 fine, and that'll be it for their first citation. If that person is alleged to have done the same thing a second time, within a 3-year period, instead of paying $500, they would pay $1,000. If that same person has a third citation issued within that time frame, 3-year period, the fine would be multiplied 4 times, so they'd be paying $2,000. And if it's more than 3 citations, then they cannot utilize the citation system for a certain time frame. So again, that's something that your local board might want to adopt. If people are concerned that someone's just going to write a check, that really, the system is not set up that way. If the people are continuing to engage in the same bad pattern of practice, the fine will increase, and at some point it'll stop. It won't be an option any further. So it's, again, something to think about. GCAR is utilizing it already. Your local board should, discuss it with your board of directors and your outside counsel and decide if that's something you want to adopt or not. I guess another advantage of the citation system would be for a local board, obviously, staff time, administrative time, and volunteer time. If you're able to resolve this with a citation where someone acknowledges wrongdoing, pays a fine, then obviously you don't have to have a hearing, you don't have to pull the panel together, you don't have to schedule it, you don't have to have the room set up, your staff person, your professional standards administrator doesn't spend time on all the forms and whatnot. So there are advantages to it. Again, you'd have to weigh those and decide if it makes sense for your local board or association.
Great. All right, so I'm Colette here. I'm just going to, now we're going to cover some arbitration. We're going to talk about grievance and the role of the grievance committee, but before we do that, I just wanted to bring your attention to the diagrams that are 2 of the handouts that kind of give you a really nice visual of what happens to an ethics complaint when it comes into the board. It shows you what the alternative dispute resource options are before the complaint gets to the grievance committee, kind of lays out what that is for both ethics and arbitration, and then kind of gives you, again, just a visual of the overall process from start to finish. So for those of you who, prefer sort of a visual look at things, do take some time to look at both the ethics chart or diagram and the arbitration diagram so that you have a sense of what the overall process looks like. But of course, we're going to be discussing in detail the role of the grievance committee and the role of the professional standards committee in this process. And Kathleen has already done a wonderful job of explaining some of the alternative dispute resources that are available to both realtors and members of the public. So those are the charts. Again, take a look at them at your leisure. So I'm going to go on to talk about the changes. And as Kathleen mentioned a little bit earlier, there were not a lot of substantive changes to the manual or to the articles this year. There is a separate document that is prepared by the National Association of Realtors that gives you very detailed information about the changes. The only thing that we could see really worth mentioning was the minor changes to Standard of Practice 1210, Article 12, and that deals with advertising, and Standard of Practice 1210 discusses the realtor's obligation to present a true picture in their marketing and representation to the public. So just to make you aware, whenever the new manual comes out, anything that you see shaded in gray means that there has been a change to that section or to that article or to whatever it is. So that is your key to let you know that this particular area has been updated or changed. So keep that in mind as we go. And again, National Association of Realtors does prepare a separate document that details the specific changes each year. So you can always access that at the National Association of Realtors website. Did you want to add anything, Kathleen?
No, good.
All right, so we're going to talk about the Grievance Committee's role in ethics complaints and arbitration requests, and we'll talk about their role in ethics complaints first. All right, so the Grievance Committee evaluates the complaint, and a couple of things to keep in mind in this process. You always want to, if you have an ethics complaint come in at the same time that an arbitration request comes in, you want to separate them, and you want to be sure to hear the arbitration request first. So we always say A before E. That's kind of the way to remember in those situations where they come in at the same time. You want to separate them and then you want to deal with the arbitration request first. So anything to add there, Kathleen?
No, I think that's good.
Okay. All right, so what does the Grievance Committee not do? All right, so the Grievance Committee does not hold hearings. Well, then you would ask, well, whose job is it to hold hearings? The Professional Standards Committee, and we'll talk about what their role is. But the Grievance Committee does not, in fact, hold hearings. They convene a meeting, and I will be discussing what they talk about at that meeting. They do not decide whether the member, a realtor, has actually violated one of the articles of the Code of Ethics. They can dismiss a complaint because of lack of evidence. And if something like that happens, which it may, then that could and does trigger the complainant's appeal rights. So they can, they dismiss it because of lack of evidence, but they could dismiss it because, you know, they decide that it shouldn't go forward. But they wouldn't dismiss it because of lack of evidence. Again, evidence or not, you have to assume that the complaint is taken as true on its face. So let me just repeat that. They would not dismiss a complaint because of lack of evidence. Evidence or not, they would have to assume that the allegations in the complaint are true. They do not mediate or arbitrate business disputes. The role, who has the arbitration hearing? Well, that would be the arbitration panel, which would consist of members of the Professional Standards Committee. So the Grievance Committee's role is very specific, and we'll talk about what they do in more detail in just a second. They have to hold regularly scheduled meetings, and National Association of Realtors has been very active in trying to ensure that this process is efficient. So the complaint, any complaint that comes into the board or into the association must be dealt with within 45 days of receipt. So that's a key thing. And you'll see throughout the manual, there are various time frames that must be adhered to ensure that the process is fair. As we go back, the beginning of the training, due process is a key, is key, basically. So the time frames are important and they matter, and they should be abided by. All right, so the Grievance Committee in Ethics. So what exactly is the role of the Grievance Committee in Ethics? So they're going to receive the complaint, they're going to review it, and I think really the key question which you will find in the manual is on page 40. So the question is, if the alleged facts in the complaint are taken as true on their face, so you assume that the information that's before you is true, the question is it possible that a violation of the Code of Ethics has occurred? So if the answer to that question is it is possible, then the Grievance Committee would go ahead and forward that complaint onto the Professional Standards Committee to schedule a hearing. So that is kind of the penultimate question that the Grievance Committee must answer. Anything to add there?
No, I think that's it in a nutshell, like you said, right there.
So there could be let's talk a little bit about, you know, what the complaint looks like when it comes in. Well, perhaps if it's coming from a member of the public, well, they may not be familiar with the process. They may not have cited an article. Maybe they cited to a standard of practice, which we said earlier, that's not allowed. You can use the standard of practice in support, but the article has to be cited. So perhaps the complaint is too vague, it's too general, it's not in the proper form. So what do? So the chair of the Grievance Committee can actually assign one of the members of the committee to provide what we call procedural assistance to the complainant. So it's very important to keep in mind that the procedural assistance that you're offering, you're not representing the complainant. You are basically simply assisting the complainant to put the complaint in the proper form. That's it. You're not representing them. And in fact, once that person assists the complainant, they would not participate in the deliberations Grievance Committee. So they make sure that the complainant understands that, and that's also important, is to make sure that the complainant makes it clear, the committee member makes it clear to the complainant that they are not representing them. So again, it's really to provide I think the key really takeaway from this slide is the committee member is offering procedural assistance to help the complainant put the complaint in the proper form. You want to add anything there?
No.
Okay, good. All right, so then the grievance committee will look at the complaint, and essentially they will have to answer all the questions that are outlined on page 40 of the manual. So what are the questions? Is the complaint, one of the questions is the very first question, is the ethics complaint acceptable in form as received by the committee? And we know what to do if the complaint is not in the proper form, because I just discussed that. And the next question is, are all the necessary parties named in the complaint? So the grievance committee will assess whether or not they are proper parties. It have to be individuals only. And then this question, number 3, is, I think, pretty important. So I want to just kind of be specific about what that question is. So it asks, you must ask, was the complaint filed within 180 days of the time that the alleged offense and facts relating to it could have been known by the complainant in the exercise of reasonable diligence, or within 180 days after the conclusion of the transaction or event, whichever is later. So the key here is to remember to ask that question, to go through that question and to analyze that in its entirety. Don't just stop at was it filed within 180 days and then toss it out. You want to make sure that you ask the entire question, and excuse me, and because we'll talk about when we get to arbitration. It's a similar question that you're asking. There have been some issues there. So just make sure that you ask, was the complaint filed within 180 days of the time that the alleged offense and facts relating to it could have been known in the exercise of reasonable diligence, or, and that's key, or within 180 days after the conclusion or transaction of the event. So both aspects of that question need to be looked at. Did you want to add anything to that?
No, that's good.
Okay. The next question is litigation pending, or is any government agency investigating this issue? And Kathleen talked about earlier, or spoke earlier a little bit about the role of your board counsel. Now, if there is litigation pending, let's say, the member of the public, it was a member of the public that filed a complaint, and they also filed a complaint with the Real Estate Commission. Well, you will want to consult with your board counsel about whether you should proceed or wait until the Real Estate Commission deals with the complaint on that end. So that would be a great example of bringing in, consulting with your board counsel about what you should do. Is there any reason the association is unable to provide an impartial hearing panel? I can't think of, and I know we talked about this before, Kathleen. I don't think we've come across any situations lately where the association was not able to provide an impartial hearing panel.
I can't think of any, no.
Excuse me, okay. So that question has to be answered. Were the correct articles cited? Making sure that the articles were cited, not the standard of practice. And then, of course, was the proper article cited? Did the complainant cite the proper article? And there's a pretty extensive discussion about that. If the grievance committee decides that the proper article wasn't cited and they need to amend the complaint, then they really need to make sure that they consult with the complainant. And why is that, you might ask? Is because the complainant is going to be the one trying to prove that, that respondent has violated one of the articles, so they have to be able to present sufficient evidence. So that's why it's important to keep and consult with the complainant, when making any changes to the complaint. And then, of course, the penultimate question, if the information, if the allegations presented in the complaint, if we assume that they're true, could there be a violation, or is it possible that a violation occurred? And again, if you determine that it is possible that a violation occurred, then the grievance committee would forward that on to the professional standards committee for a hearing. Any points on that?
No, you're good.
All right. So then we go on to say just a couple of things to be reminded of. One is that the grievance committee can actually request additional information from the complainant. That's, any information that's not on the complaint, but only if, and that's key, only if necessary to determine whether a complaint will be referred for a hearing. So again, to keep in mind that only if is necessary in determining whether or not a complaint will be referred for hearing. Additionally, the grievance committee may require a response from the respondent. But there's a caveat, only if the committee is in need of additional information and the complainant cannot provide that information. So those are very specific roads to go down. So you want to make sure that you're clear about that. Anything to add there?
No, I think you're doing a great job.
All right.
Keep on rolling.
All right. So then we go on to what do you do. So you have your meeting, and then you either decide that the complaint needs to be amended, perhaps maybe the proper article wasn't cited. If you've got everything you need and you just make the decision to forward it, so is it possible that a violation occurred? If the answer to that question is yes, then you would go ahead and forward it on to the Professional Standards Committee for hearing. If it's not possible, if you don't believe, if the Grievance Committee as a whole doesn't believe it's possible that a violation occurred, then they would dismiss the complaint. And as I said earlier, that would trigger the complainant's appeal rights, which we will talk about a little bit later.
Right. I was just for this. I'd like to, concept-wise, I like to think of this like as a traffic light. Honestly, at the end of the Grievance Committee, when reviewing an ethics complaint, the end result, I guess they have three options: basically red light, green light, yellow light, and that's what this would be. Basically, red light, it's going to be dismissed. It's not possible there was a violation. That's going to be dismissed. The yellow light would be it's probably going to move forward, but we need to slow down and pause first. So we're going to amend the complaint and then move it forward, or it's going to be amended and move forward. And green light, basically, it's suitable as submitted, and it can just move forward to the hearing process. So that's concept-wise, I think that kind of makes sense.
I think that's helpful.
All right, I think that's it. Okay, Kathleen, again, we'll start back. Colette just did an excellent job of discussing the role of the Grievance Committee in ethics. I am going to discuss the role of the Grievance Committee in arbitration proceedings, and there's a lot of parallels here. The review process for the Grievance Committee for reviewing a request for arbitration, those factors are also in the manual. They are set forth on page 142 if you want to tab your book or whatever. If you need to review those or just want to, it's an important page. The factors are up here on the slide as well. Is the complaint, is the request in proper form? There are forms that have to be utilized. There's certain information that has to be on there. Specifically, the second one's important. Are all of the necessary parties named? That is going to be the realtor principal. Basically, typically that's the broker generally, or office manager who's going to be involved. The agent, we get this call or question on the legal hotline a lot of times. The agent may feel like if they were the procuring clause, they're going to file a request for arbitration. The agent cannot do it alone. It can't be just the agent. The broker has to be a participant in this, this proceeding. So that would be something that would be an issue that they'd have to take a look at. Is it timely filed? That, again, is something that Colette had addressed as well, and it's the same consideration. It's going to be the later of 180 days after the closing of the transaction, or 180 days after the facts constituting the arbitrable matter could have been known in the exercise of reasonable diligence. So the later of those two dates, and again, as Colette had said in the ethics arena, it's not just automatically drop dead at 180 days. So the Grievance Committee needs to be aware of that limitation as well. Are the parties members in good standing? Were they members at the time the facts occurred? That would give the association jurisdiction over the dispute over the parties. Is litigation pending? Again, that would have to be considered as well. That's relevant. If there is litigation pending, then no arbitration will take place unless it is court ordered or the litigation is withdrawn. Again, similar to the ethics thing that Colette just mentioned, I would discuss this with your board counsel just to be on the safe side there. The next point, is there any reason the association is unable to provide an impartial hearing panel? Again, I'm not aware of any, but I suppose it could happen. Can you think of anything?
No.
Yeah, I can't off the top of my head. Is arbitration mandatory or voluntary? That's another thing that the Grievance Committee would need to look at. And we have the next slide, I think, will go into a little more detail on that. The final point here, is there too much or too little money in dispute? And is the matter too legally complex? There's a little bit of a discussion in the manual on that. Is the matter too legally complex, involving issues that the arbitrators may not be able to address in a knowledgeable way? Maybe an easy example of that might be if it's a commercial transaction.
Right.
Maybe that would be more appropriate for litigation in court rather than moving forward with an arbitration. So that would be something, again, you should discuss with board counsel. It might not be the best option for your board to handle that type of situation if it's legally complex.
Yeah.
All right, anything you want to add there?
No.
Okay. Mandatory or voluntary, I think everyone knows the definition of mandatory and voluntary, but mandatory, the parties must submit to arbitration unless they both agree in writing to bypass arbitration and go to court. Again, if it's a legally complex or a high dollar amount, they may be perfectly willing to do that.
Right.
Voluntary arbitration, the respondent has the option to decide whether or not to arbitrate. So we have a chart on the next slide, and again, really what you want to think about is who is the respondent. So look at the mandatory column, principal broker versus principal broker at different firms. Those are going to be members, right? So as a member, you have consented and agreed to participate in the professional standards process, including arbitration. So a principal broker at one firm has filed a complaint, request for arbitration against a principal broker with another firm. That is mandatory. That's probably the most frequent occurrence. Most of the arbitration requests would be of that type, mandatory broker from one company with broker from another company.
Right.
The second one in the mandatory column, agent versus agent at a different firm. If the brokers agree, again, that's, you know, the brokers would have to be involved in this and consent. Client versus broker, again, that's going to be mandatory because, again, the broker as a member has agreed and consented to this process. So if the client is willing to consent to it and utilize this process, then the broker has to participate. The voluntary column, again, agent versus agent at the same firm, that's optional. I guess the broker or office manager may resolve it internally for reasons of office politics or harmony. They may prefer to have it resolved by the local board, so that would be voluntary. Broker versus a non-member broker, again, remember, we've all consented as members of our association to this process. A non-member has not consented, so it would be considered voluntary. If they're willing to participate in this process, then they can. Broker versus customer, same thing. The customer obviously is not a member, has not agreed to participate in this process, so if they want to, they can. If they do not want to, they cannot be required to.
Mm-hmm.
All right, so the grievance committee, the options here for the grievance committee with a request for arbitration, we'll go back to the old stoplight analogy that I just used a couple seconds ago. The resolution or decision-making process for the grievance committee with the request for arbitration, it's not going to be 3 options. There really are only 2 options, and the committee can either forward it for hearing or dismiss it. So basically, red light, green light at this point. They don't have the option to amend it or, you know, suggest to the complainant, you should say this, you should do this, whatever it is. Really, red light, green light, it's going to be moved forward or it's going to be dismissed.
Yeah, and just to add, and Kathleen will be touching on this, if it's, for example, dismissed, then that would trigger the complainant's appeal rights, and we'll talk about the different, the different appeal rights. Also, if the grievance committee determines that, let's say, it's voluntary versus mandatory, then the complainant could, appeal that decision. So there, as I said earlier in the training, there are different aspects or different stages in the process that trigger appeal rights for the parties.
Good. Thanks, Claude. Those are good points. All right. So next, we're going to talk about these are just sort of basic concepts, sort of general policies or general information that would apply to either, any hearing really in the professional standards process, general policies and procedures. Some of these are common sense, but, let's just think about it. Sometimes in a hearing, common sense doesn't prevail. So you might have to think about some of these things, or if you're the chair of a panel, you may have to remind people about some of these things, even if it does appear to be common sense.
Yeah, I mean, I'm sorry, I didn't mean to interrupt you. I like to think of this part of the training as really as best practices, and these are based on a lot of these tips come from actual issues that have occurred in previous hearings and, situations. So,
right, good, that's a good point, best practices. So first, all hearings have to be recorded except for appeals or procedural review hearings or executive session. You're not going to record executive session, but the hearing itself is going to be recorded. So that means you, as an association or a board, you need to have a tape recorder or a court reporter present. And that's not optional, that's required.
Right.
So it has to be recorded. Does the association provide the parties with the option to record? I think Colette had touched on that earlier. That's a local board option.
Right.
So you can, based on what your board has decided, that you may or may not offer that to the parties. The parties have a right to a copy of the recording or transcript, subject only to they'd have to pay for whatever the cost is for duplicating it or getting a copy of it. And again, that would be used only for appeal hearings or procedural reviews. Tips, these again, best practices, as Colette had noted. If you don't use a court reporter, make sure that everyone states their name prior to asking a question or providing an answer. That's going to be important. If you're listening to a tape recording, you just hear a voice, you probably, when I do who it is, yeah, you want to make sure you know who it is. Also, consider having 2 tape recorders at every hearing. Always check the tape to see if it's being recorded. Sometimes there are issues with recordings. You don't want to have to go back and redo something. So I would say it is a good idea to have 2 tape recorders available. If they're battery operated, obviously check the batteries or have extra batteries available just to be on the safe side. If you have a staff member who has some OCD tendencies, this is a great role for them to kind of really think about what could go wrong and to prepare for anything that could go wrong. Again, the hearing procedures in both arbitration and ethics, the procedures and issues and questions should be reviewed prior to convening the hearing. This basically, there's a pre-hearing meeting that can occur, and that's the appropriate time to address any administrative issues that might be out there. If there's some question about whether the matter was timely filed or whatever it might be, that's an appropriate time to address those issues prior to the hearing. You want to have those issues resolved, have the panel all on board, understand everything before the hearing starts. Watch the chit chat. Again, this kind of ties back to due process and having the parties feel like they received a fair hearing, an impartial hearing. If one of the panel members knows one of the parties and is chit-chatting back and forth about them playing golf on Saturday, the perception of the other person is not going to be good. So really just be mindful of that and try to minimize that type of thing wherever possible. Keep your hearing room door closed. Again, that ties back into confidentiality. This could be a sensitive matter that someone could be assessed a fine or, something that, an ethical violation. No one feels good about that if you're found to have violated the code of ethics. So that's not the kind of thing you want the door open for. And, every member of some committee who happens to be in your office that day, or if there's a class, everyone who walks by hear what's going on. You really want to be mindful of that as well. Respect for the parties and respect for the process. Panel members should not wear their company name tag or anything that identifies them with a particular brokerage. The association should use tent cards and just have the name of the panel members and don't identify which brokerage they're affiliated with. When asking questions, the panel members, again, this is kind of common sense, but you might need to be aware of it or be mindful of it when you're in the middle of a hearing. You should watch your tone of voice. You want to ask questions in a neutral way. Again, you're trying to make sure that the participants feel like they're getting an impartial panel, right? So you don't want to show that you favor one party or disfavor the other. You're going to keep a neutral tone of voice. You also want to wait to be recognized by the chair. Again, remember this is being recorded, and if 2 people are speaking over each other or 3 people are speaking over each other, it's going to be very difficult to figure out who said what on that recording. You really do not want that to happen. The chair is going to keep control of the proceedings, and the chair is going to identify who's going to speak and when they're going to speak, and you shouldn't speak until the chair has recognized you. Avoid leading questions. You want to ask open-ended questions. It's basically to gather facts without any judgment, really. You shouldn't be expressing judgment in the way you phrase the question or ask the question or lead them to an answer. Well, surely you sent that over. Of course you sent the counteroffer over, right? That's not the way to ask that question. You can ask the person to discuss the counteroffer. What happened with the counteroffer? That would be you don't want to lead them to the particular answer you want or you think that they want. Ask questions in a positive, open-minded manner. Ask questions to clarify, not to help either party. And questions to clarify, that's very important. Again, remember, thinking about arbitration again, ethics. Ask questions to clarify, don't help either party. You are to be a neutral party in this process. You're not there to help one party or help, hurt the other party. So you're going to ask questions just to clarify facts, clarify what happened or why it happened, not to assist either party or help strengthen their case. Again, in asking questions in a neutral way, you want to avoid words like why, why did you do that? Or shouldn't you have done this? Those are judgmental questions, and you don't want to ask questions using those words or those terminology. All right, did you have anything to add there, Colette?
Just a couple of things, just to kind of reiterate the importance of asking the open-ended questions. You kind of want to stick with the sort of the who, what, when, and Kathleen was talking about, why did you do that? Questions like that, you want to put them in context. So, I'm trying to understand why, so it doesn't come across as if you're, upset or judging.
Yeah.
Right. And then the other important thing to remember about the asking questions is you only have this one shot. So you really, essentially. So you really want to make sure that you ask whatever questions you feel you need to, because once you go into executive session, you really don't have the opportunity to go back and, talk to the witness or ask the witness a question or ask the complainant a question. So get all the questions that you have, feel comfortable to ask any questions that you have, because ultimately your task is to prepare a findings of fact that has a clear rationale. So that's important. So ask questions, whatever you need to do so that you are able to arrive at a reasoned decision.
All right, good, thank you. Good point. Etiquette, again, avoid shaking your head, rolling your eyes, any sort of facial expression that might communicate that you're not impartial or you're showing bias. You really want to avoid that. Avoid showing that you're tired or bored. In court, they'll refer to someone as having a judicial temperament. And basically, I think that means, can you keep a straight face to a certain extent? And you really do need to try and do that throughout this process. Need to be a good listener, ask for clarification when needed. Again, as Colette had just pointed out, that's going to be important, especially, it's important, obviously, you want to be clear on what happened and what the facts are, but especially if you're going to be writing finding of facts. You need to make sure that you understand the facts and you are able to write a clear and complete finding of facts. So if there is an appeal or going to be reviewed by the board, you want it to be clear that anyone who was not in the room can read what you've written down and understand the facts. So that's what you want. That's where you want to be. Again, these, like Colette said at the beginning, these are best practices, and believe it or not, some of these things have occurred and have actually been problems. So pay attention to this. No cell phones. People should not be using their cell phones during the proceeding. The cell phone should be turned off. No iPads, no electronic devices. This really is important. Someone's livelihood or their membership certainly would be at risk. That could be, arbitration is going to be a big financial award. So you really want to make sure that the panel comes across as focused and fully involved in the proceedings, not distracted by whatever might be going on with their cell phone or their electronic device. As a courtesy, panel members should not eat during the hearing. Again, that seems like common sense. Just, I guess, be mindful of that when you're scheduling your hearings, what time you schedule them for. Maybe schedule it at 1 after people have had time to eat lunch, or schedule it at, whatever, early enough, but allow a lunch break if necessary. You really don't want people ordering in subs and pizzas while the hearing is taking place. The panelists really should not leave the room unless they ask for a brief recess. Of course, someone may need to use the restroom or whatever. That's perfectly permissible, but the proceeding should stop for a minute, a recess, while someone needs to do that. Someone should not just get up and leave the room without making everybody else in the room aware of what's going on. All right, anything else there, Colette?
No.
Okay. Hearing procedures, we had touched on this, I guess, briefly. When asking questions, the panel member, you want to allow each side to present their case without interruption. Don't watch the Supreme Court. Some of those judges interrupt the parties, or certainly don't watch congressional hearings where they interrupt constantly. You really want to be impartial and neutral in these, as you're going to allow each side to present their case. If there are procedural questions, you are going to direct those questions to the chair. The chair is going to make a decision about all matters of procedure. An easy example of that, the parties would if they're going to submit any documentation or evidence, that all should be submitted in advance of the hearing. If for some reason someone comes to the hearing and then printed out an email that they had not previously submitted, they want to use it as part of their presentation, they want to use it as evidence, they would have to address that to the chair. The chair would have to decide whether that's going to be permitted or not permitted. So that would be an example of that. All right, the role of the chair, any member of the, I'm getting myself lost. Any member of the panel could be appointed as the chair. The chair controls the entire hearing, and we touched on this a little bit as well. The chair monitors the behavior of all the participants, so that's going to be the parties, of course, their counsel, if there are any witnesses, whatever. The chair also has to control the behavior of the panel. Kind of the points that we've touched on earlier, if a panel member is asking questions inappropriately or rolling their eyes or, tapping their fingers with impatience or whatever it might be, the chair needs to be mindful of that and keep an eye on that and, kick somebody under the table or whatever they need to do, but the chair needs to be able to manage that as well and handle situations as they arise. Again, there's going to be a record for most of these things. The people will have a right to appeal as well. So it is important to address situations as they arise, as they take place, not kind of keep your fingers crossed and hope everything works out. That's really, again, the fourth point here, due process is provided. That, again, is really the focus of all of this. The participants need to feel that they received a fair hearing, that the procedures that are in place were followed, and they received the benefit of due process throughout. The chair is going to call the hearing to order. They are going to swear in the parties and the witnesses. There actually is a script in the manual for the chair, and it really is a script. You can read it out loud. And for the ethics hearing, that script is on page 83. For arbitration, it's on page 195. So that's the opening statement, right? In the opening statement, it's the NAR language, so it's all going to be there. The chair is going to cite the authority to hold the hearing and read the complaint into the record. Another point I maybe should have mentioned previously, the panel members should address the parties by Mr. or Mrs. Again, that's a way to keep neutrality or keep impartiality. You want to call one of them, Buddy or Skipper, whoever it might be, and refer to the other one as Ms. Jones. You want to be consistent there and address them by Mr. or Ms. All right, so the chair is going to read the ethics complaint or the request for arbitration into the record. Again, like I said, following the opening statement script that's in the manual. Then the parties and witnesses that are going to testify have to be sworn or affirmed, and the witnesses are going to leave the hearing room until called upon for their testimony. So again, this is similar to a court proceeding. You don't want the witnesses to be influenced by hearing what another witness says. So, witness number one will be in the room. All of the other witnesses will be outside in another area waiting when witness number one finishes. If the party wants to call another witness, witness one will leave, witness two will come into the hearing room. Right. The parties are going to present their case. In addition to testimony, each side's presentation can include introduction of evidence. Like I said, that could be, documents or a copy of the contract or copies of emails, whatever it might be. The chair is going to keep the evidence and decide whether something is relevant, whether something is going to be admitted as evidence or not. The chair marks the evidence. They'll mark an exhibit, complainants, exhibit number one, respondents, exhibit number one. That makes it easier. Again, remember, if this is being recorded, it's easier to refer to documents that way. Rather than wait, that's the notice pursuant to blah, 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 whatever. It's just easier to identify them by exhibit number, keep everything clear, right. That, which document is being discussed. And the parties are allowed to review exhibits as well. In the manual, there's an ethics hearing checklist. That's on page 57 of the manual. There's an arbitration hearing checklist as well. That's on page 171 of the manual, if you want to tab those pages. The last page of each section there's an administrative time frame for the ethics process and administrative time frame for the arbitration hearing as well. That's on page 62 for ethics and 175 for arbitration. Those are good pages to review before a hearing or as part of the process. Confidentiality, I think everyone understands that. Confidentiality is really important, obviously, before, during, and after these proceedings. All of your panelists, all of your staff, everyone should zip it, I guess. It's pretty straightforward. again, respect for the parties, respect for the process. This is not something you're going to go out and talk about with your best friend and tell them so-and-so was, oh, so-and-so had to pay a $5,000 fine. That is not appropriate. That should not take place.
Yeah, and just to touch on that a little bit, just Colette here, as Kathleen said, this whole process is confidential. Now, and it's different because if somebody is found to have violated Maryland law, then that information is public record, and you can actually access that information on the Maryland Real Estate Commission's website. But this process is all confidential. The manual does outline the scenario where the board of directors can choose to make public information where a member has been, charged with a violation or found to have violated, but no board in Maryland has, no board of directors of any board in Maryland has elected to make any of that information public. So absolutely, this entire process is confidential.
Yeah, that's a good point. Thank you. I'm not sure if that's the trend, if that's going to be something that more boards do or do not, but that's a good point. Thank you.
Yeah. All right. So we go on and talk about professional standards, hearing, and ethics. And before we get into some of that, I'd like to speak on a little bit about the two legal terms that you'll probably need to be kind of very clear about. And so the first one is what we call the burden of proof. The burden of proof in an ethics proceeding is on the complainant. Well, what do we mean by the burden of proof is on the complainant? Well, that means that the complainant has the responsibility to prove that the respondent actually violated the code of ethics. So the complainant, the burden, we say, is on the complainant to establish that a violation has occurred. Now, we included this football field kind of analogy with the number line, and you'll see the red arrow is way sufficiently past
the opponent's 30, I would say, meaning you've gone 70 yards down the field.
Yeah, so the burden is on the complainant to prove that the respondent violated the articles. And then, of course, we have our second important legal term, which has to do with the standard of proof in an ethics proceeding. So we say the standard of proof for ethics proceedings in determining whether or not a violation has occurred is clear, strong, and convincing. And that's really where the arrow comes in, because the arrow, what does that say about the evidence? And we talk about standard of proof. We're talking about the amount of evidence needed to make the case. So if you look at that arrow, it's at, what is it? I guess is that
so like 70 yards.
Yeah,
total,
like 70 yards. So that's pretty firm. That's pretty a significant amount of evidence. And remember, the hearing panel has the ability. One of the penalties is, to expel the person. So before you do something serious like that, you have to have a sufficient amount of evidence and have it in your mind that is, the evidence is clear, strong, and convincing. So what does the manual say, just so you're aware? And this would be a really good place to tab in the manual as well. It says, if you go to page 23, number 26, which is the burdens and standards of proof in ethics and arbitration hearings. For ethics, the standard of proof is clear, strong, and convincing. So that's actually the third paragraph. And it says, clear, strong, and convincing shall be the standard of proof by which alleged violations of all membership duties, including violations of the code of ethics, are determined. Clear, strong, and convincing shall be defined as that measure or degree of proof. And again, we're talking about evidence, degree of proof which will produce a firm belief or conviction as to the allegations sought to be established. So you need to be kind of pretty sure that the information, the evidence that's been presented, creates in your mind a strong belief that the respondent has actually violated one of the articles. Anything to add there?
No.
Okay.
You've been very clear on that. And strong.
Clear and strong, right? Clear, strong, and convincing, hopefully.
Yeah, exactly.
So the panel's decision must be based on the testimony of the parties and witnesses and any evidence they present, agreements, anything like brokerage or whatever it is, Evidence can include statements, affidavits, documents, papers, and again, the burden of proof is on the complainant. So if the information was not introduced during the hearing, then the panel cannot speculate. And that is why I said earlier when we were talking about hearing procedures, mentioned the importance of making sure that not only do you ask the open-ended questions so that you don't come across as being judgmental, but you also ask however many questions you need to ask so that you're able to arrive at a reasoned decision. You don't have to wonder about anything. You need to be sure about, what the decision is based on the information that's presented. So the key is if it doesn't pass the smell test, it's not clear, strong, and convincing. So anything to add there?
No.
All right. So once the parties have had a chance to make their case, then essentially the chairperson will close out the hearing and they will go into executive session. And so what happens in executive session? The committee members, the hearing panel comes together and they decide by a majority of votes whether a violation has occurred. And it has to be in writing, so you want to tab form number E11. That's the form that you need to disseminate the decision. And again, I will say, as far as the findings of fact are concerned, you want to make sure that you tell the parties and the board of directors what happened and provide a rationale as to a violation or no violation. And what I always kind of like the visual or kind of picture that I like to say about this is you want to write your findings of fact in such a way is that so that somebody who was not in the hearing can read it, understand the facts that you relied on and how you arrived at your decision, and essentially what your rationale was. So I should be able, if I'm not at the hearing, I should be able to read this document, read this findings of fact, and understand exactly how you arrived at the decision. That's really the key. Anything to add there?
No, that sounds good.
So,
all right. This will be, I'll take over the next couple slides here. If an ethics violation is found, what authorized discipline can be imposed? And again, the concept here is it's a progressive system of discipline, and that's part of the due process. Again, someone who has committed a first-time offense, relatively minor or inadvertent offense, generally you wouldn't expel them from membership and fine them $15,000. So it's progressive discipline and approved, I guess, authorized discipline is the key as well. So the mildest discipline that would be issued or appropriate would be a letter of warning, which would be in their permanent record. I think as the high school movies always say, it's going to be in your permanent record. A letter of reprimand. The third one is perhaps the most frequent, education. If someone has found to have violated the code of ethics in some way for maybe not documenting something properly, maybe the discipline would be that they would take an ethics class and a contracts class, or one or the other. That would be an appropriate type of education or class that would make sense. It would have to be something that's approved by the board. Actually, let me point out in the manual on page 36, there's a little bit more discussion and fleshing out these points a little bit more about the nature of the discipline that can be imposed. The classes, the explanation for education says the member may be required to attend the ethics portion of the board indoctrination course or other appropriate course or seminar specified by the hearing panel, which the respondent could reasonably attend, taking into consideration cost, location, duration. Generally, it's going to be a CE type class. It wouldn't be appropriate to suggest that someone, go take yoga. Although, in all honesty, that probably would help. That's not appropriate, an appropriate sanction in this kind of situation. I guess, increasing severity, a fine could be imposed up to $15,000. Membership can be suspended for not less than 30 or more than a year, and the member can be expelled from the association for a period of 1 to 3 years. So, as we pointed out earlier, these are pretty significant consequences. The concept in mind here, basically, the punishment should fit the crime. That's really the way to keep that in perspective. There are further guidelines in there, I guess, about discipline, what the panel should be considering or looking at. That's on page 65 through 69 of the manual. And again, just in general, a minor inadvertent mistake, first time anyone has ever been disciplined, that would make more sense for maybe education or a letter of reprimand or something like that. If it is someone who has engaged in the same conduct previously, if they're a repeat offender, or it is something that is probably not inadvertent, it seems like it was intentional or deliberate, then obviously a steeper discipline might be appropriate. All right, public trust violation, this comes up. This is important to keep in the back of your mind. Hopefully, in the perfect world, you won't see any of these or many of these. But like I said, in general, we spoke earlier, the Realtor Association, we're in one world. The Maryland Real Estate Commission is separate and apart. They have the authority to discipline or to revoke someone's license. We really don't. This process is completely separate from their process, really with one exception. If our process discloses there's been a violation of the public trust, then it would be referred to the Maryland Real Estate Commission. So obviously the violation of the public trust, that's not going to be an inadvertent failure to send over one addendum. That's going to be a really significant matter. That's defined in the manual as well. In Part 1, Section 1, that's a little letter 2, lowercase t there. It's basically defined as misappropriation of funds or property, fraud resulting in substantial economic harm, or willful discrimination. So if that's what has come up in your case that was presented to your panel, then that would be referred to the Maryland Real Estate Commission. That's I guess, a public policy there that makes sense. You know, we shouldn't allow these type of things to go on and not bring it to the attention of the state. So that would be brought to the Real Estate Commission's attention as well. Did you have anything else to add there, Colette?
No. I don't. I think that's good.
Okay. All right.
All right. So now we put on our arbitration hats, and we're going to be talking about the role of the Professional Standards Committee in an arbitration hearing. But before we do that and get into that sort of in-depth discussion of procuring cause, I wanted to go back to these two legal terms that you need to be aware of. So we've got the burden and standard of proof in arbitration. We talked about the burden and standard of proof in ethics. Now we're talking about the burden and standard of proof in arbitration. So just as is the case with ethics, in an arbitration proceeding, the burden of proof is on the complainant. What does that mean? What it means is that it is the complainant's responsibility to prove that they get the money or that they are entitled to the compensation. So that is what burden of proof means. And in the arbitration context, the burden of proof is on the complainant, as well it's also on the complainant in the ethics context. All right, so now we go on to talk about the standard of proof, which again has to do with the amount of evidence needed to make the decision, essentially. So the standard of proof for arbitration is the legal term that we call preponderance of the evidence. So if you look at go back to page 23 of the manual, in that same section under section number 26, you will see the discussion of the preponderance of evidence and what that kind of means. And I'll just read that briefly. The standard of proof on which an arbitration hearing decision shall be based is a preponderance of the evidence. Preponderance of the evidence shall be defined as evidence which is of greater weight or more convincing than evidence which is offered in opposition to it. That is, evidence which as a whole shows that the facts sought to be proved are more probable than not. So the key there is more probable than not. And if you look at this football field and you see where the arrow is in this type of proceeding, it's that they're just hovering over the 50-yard line. And I always like to hear Kathleen's evidence story.
The one example I use, actually the football analogy, my law school evidence professor used that. I think it's a really good way to show it. The example I use for this, for preponderance of the evidence, or more likely than not, is, and I will say I'm a Ravens fan, and there was a situation recently that most of you, any football fans may be aware of. There was a quarterback from another team, who I won't say his name, but there were allegations this quarterback had instructed the ball boy to deflate some of the footballs. And the NFL investigated the matter and they hired an outside investigator, and the report was written up. I think it was 85-page written report. And throughout the report, there were statements made saying that it was more likely than not that the quarterback had been aware of this, more likely than not that the quarterback had directed this conduct, et cetera, et cetera. And everyone I knew who was a fan of that team sort of dismissed that as nonsense. More likely than not. What does that mean? That doesn't mean anything. In reality, it does mean something, and that's exactly what it means right there. It's beyond the 50-yard line. So that's what, it is a legally recognizable standard.
Yeah.
So sorry, you Patriots fans. Okay. That's enough. That's the example I used just to explain that concept. That's probably enough about that.
All right. So great. So I think you get the idea. Again, I think the key is of greater weight or more likely than not. So keep those two standards in mind as you're dealing with arbitration. You have to keep them in mind because they're how you judge the evidence and so forth. So now we go on and talk about procuring cause. And I would say, and Kathleen, you can say too, how many questions do we get about procuring cause just in classes and on the hotline, wherever we are?
Yeah, I don't know the percentage, but a lot. It's a pretty regular question.
At least several. I know for me, at least several times a month, I'm getting questions about. Essentially, we're given a fact pattern, and then the question is, well, am I procuring cause of the transaction? And of course, we really can't say that because we don't have the benefit of having all the evidence. But what we typically do is direct people to review this section of the manual that we are getting ready to cover in some detail that explains what procuring cause is and explains what the factors are that the arbitration panel must consider in determining which broker is entitled to the compensation, or as we like to say, who gets the money. Okay, so for purposes of arbitration conducted by both boards and associations, and you'll find this definition. I actually just sent out the 2018 manual to somebody who had the question on, Monday. I think it was Monday, yep. Okay. And we actually had some discussion about this. So the discussion of procuring cause you will find on page 158 of the manual, and the definition of it is in the second column in the middle of the page. So it says, procuring cause in broker-to-broker disputes is defined as the uninterrupted series of causal events which results in the successful transaction. So again, it's the uninterrupted series of causal events which results in the successful transaction. So all that information I just read out to you is important to understand. So you have to say what caused, you have to ask what caused the successful transaction to come about. The arbitration panel does not determine whether the law or the code of ethics was violated. Arbitration is not about wrongdoing, it's about who gets the compensation or who gets the money. So we're going to talk just a second about what a successful transaction is, and I'm not making this up. This is defined in the manual. So a successful transaction essentially is a sale that a transaction that settles or closes, or a lease that is executed. That is taken directly from the middle of page 158 of the 2018 manual. So again, a successful transaction is a transaction that settles, a sales transaction that settles, or a lease that is executed. So hopefully that makes sense. So now we get into some more detail about procuring cause. And so we kind of inserted this little quote here. It is the squirrel that shakes the branch and not the squirrel that gathers the nut. So again, uninterrupted series of causal events which results in the successful transaction. So how do we get there? That is the question that the arbitration panel will decide. So, and you can follow along if you like, reading from, well, not reading, but on page 159 of the manual spells out the factors that the arbitration panel will need to consider in deciding or making the determination as to who gets the money. So we look at factor number one, which I think is really important to point out. So factor number one says no predetermined rule of entitlement. What does that mean? Well, it means that every arbitration hearing panel must look at all relevant facts and circumstances presented by the parties and their witnesses There's no rule of thumb. Prior decisions by other panels are not factored in. Threshold, contract in hand, and agent relationships by themselves do not determine entitlement to compensation. So I really want to point you to the second paragraph of the factor number 1 on page 159, because I think this is something that a lot of people do not understand or realize. So here's what it says. It says procuring costs shall be the primary determining factor in entitlement to compensation. Agency relationships in and of themselves do not determine entitlement to compensation, which a lot of people are not clear about. It says the agency relationship with the client and entitlement to compensation are separate issues. A relationship with the client or lack of one should only be considered in accordance with the guidelines established to assist panel members in determining procuring cause. So again, procuring cause is the issue here. That's what we're trying to figure out. Agency relationships in and of themselves do not determine procuring cause. Does that make sense?
That does to me.
All right, let's go on. So factor number 2 deals with the arbitrability and appropriate parties. Now, we said that the Grievance Committee usually kind of makes this determination, but if any issues of this sort arise, the hearing panel can also certainly take care of them and consider them and deal with them. They can consider questions of whether an arbitrable issue exists. They can consider whether the proper parties are named or appropriate to the arbitration. So again, typically, this is dealt with by the Grievance Committee, but if any of these types of issues arise, then the hearing panel certainly can deal with them. Okay, good. Going on to factor number 3, relevance and admissibility. So Kathleen talked about this a little bit before. The panel may be asked to rule on questions of admissibility, whether or not they're relevant to the issues at hand, and the chairperson will make those determinations. Will make that determination. Generally, state law controls anything that the hearing panel believes will assist them in reaching a fair and equitable and knowledgeable decision is admissible. So again, this kind of touches back on that whole very important concept of due process. So anything that the hearing panel believes is relevant, that will help them arrive at a reasoned, equitable, and fair decision, they can admit. They are looking to resolve contractual questions, not, again, to reiterate, not whether the code of ethics was violated. So anything to share there, Kathleen?
No, I think that's good.
All right. So the panel member be asked to rule on questions of admissibility. Unlike a judicial proceeding, there's no discovery in arbitration or ethics hearings. There's no examination before trial or deposition. Hearing panels are entitled to consider all relevant evidence. So just really reiterating that. Relevant evidence, testimony, in order to have a clear understanding of what happened. And again, as I said before, and I'll say it again because I think it's important, ask however many questions you need to ask of the parties or the witness or any evidence that they present, so that when you go into executive session, you have all the information that you need to arrive at the appropriate decision. Factor number 4 deals with communication and contact, abandonment, estrangement. So the questions like, did the broker's inactivity or perceived inactivity cause a buyer to conclude reasonably that the broker had lost interest or disengaged? Did the broker engage in conduct or alternatively fail to act when they should have or terminate the relationship? All these kinds of questions are important and may be relevant in making that ultimate decision. Possible ethics violations. So again, the possible ethics violations can be considered as part of the evidence, but cannot be used to withhold an otherwise substantiated award. Possible ethics violations should be considered as only one of many potentially relevant factors, and we have several factors. Over 200 to 250 questions that may be necessary to ask. I mean, obviously not all at once, but there are many factors in this. Arbitration panels do not make referrals of ethical concerns. So just remember trying to separate out that issue and dealing really primarily with who gets the money. Factor number 5, conformity with state law. So the arbitration procedures must be in accordance with state law. And of course, if you're not sure about any issue related to this, arbitration procedures comes up, then you want to make sure that you consult with your board or association counsel. Anything to add there?
No, that's good.
All right, so factor number 6, consider the entire course of conduct Panel members may ask questions of parties or witnesses to substantiate their understanding of testimony, to clarify events in their minds, what happened, what didn't happen, what led to the transaction, what led to the successful transaction, and to the arbitration request being filed. Have panel members review the questions provided, and in fact, have a copy of the arbitration worksheet. Now, the arbitration worksheet, you want to make sure that you tab this, because you definitely want to have this worksheet handy when you are at the arbitration proceeding. It's page 165. So essentially what the arbitration worksheet did was take all the questions that are outlined beginning on page 160 and put them in a organized sort of format. So you take your arbitration worksheet into the arbitration panel, the arbitration hearing with you, and you ask whatever questions you think would be appropriate to help you arrive at the decision. Just to give you an idea of some of the kinds of questions that you will see or may need to ask. So for example, on page 161, under initial contact with the buyer, says who first introduced the buyer to the property, when was the introduction made, under conduct of the broker, of the brokers, one of the questions is, were all required disclosures complied with? Was there a faithful exercise of the duties the broker owes the client? So these are, as you can see, are kind of who, what, when kind of questions that are designed to elicit a narrative, to give the party or their witness an opportunity to elaborate and explain exactly what happened. Anything to add there about as far as the factors?
No, I think
or the worksheet, the arbitration worksheet?
Really, just I would suggest people take a look at the arbitration worksheet. That's very helpful.
Yeah, and not only look at it at the hearing, but review it before the hearing,
right.
So you have kind of in your mind what you need to be focused on. All right, so in an arbitration proceeding, the hearing panel members, including the chair, will go into executive session. There's no findings of fact, generally. I believe there is one board where the Cecil County, I believe, where the court system has mandated that.
Right.
But for the most part, there's no findings of fact in an arbitration proceeding. The decision is made by a majority of arbitrators and signed stating the amount of the award only. There's no interest, no attorney's fees, no damages. It's essentially who gets that compensation. It says, when signed and served on each party, the decision is binding and not subject to appeal except on due process grounds. So what does that mean? Well, it means if you don't like the amount of the award, that's not an appeal. That's not something for which you can request that, you know, there be an appeal. If a panel member made a wrong decision, or if you disagree with the arbitration panel's decision, that's not a basis for making the appeal. The only basis for making the appeal in this context is for any kind of due process issues having to do with fairness or lack of impartiality or anything along those lines. Those types of issues are appealable, but not, I don't like the award. Okay, anything to add there?
No.
If no procedural review request is filed within 20 days of transmission of the arbitration award, then the decision is final. So that is the process for arbitration. And as you can see, it's a very nuanced process. You've got the several factors there to consider, various questions to ask, understanding that agency and procuring cause are separate issues. So you've got to keep all this very important information, you know, successful transaction, all that in your mind as you are listening to the parties before you and their witnesses and making an informed decision.
And I think that's just, again, tying back to what you had said earlier, I think it's a little bit frustrating for people sometimes that they don't understand that there are so many nuances and so many aspects to consider. People calling the legal hotline, they really do want us to say, like, yes, you're the procuring cause. Right. And it really is not that straightforward. So again, that's why it's important to use the chart and follow the guidelines carefully.
Yes, absolutely.
All right, we are coming into the home stretch here. We are going to talk about the role of the board of directors in the professional standards process. The board of directors, basically their role is kind of twofold, really. They are the safety valve, is probably the best way to express it, the best way to think about it. Part of their role will be to correct errors or mistakes. If there's something should have been done or should not have been done, then the board of directors has the authority and responsibility to correct that. The second part up here is also important, though. The role of the board of directors will be to help prevent lawsuits against the board, right?
Yeah.
So that's sort of a risk management thing, and those two definitely go together. If the board reviews things and makes sure that everything was done properly, corrects anything that was not done properly, then it's less likely that you'll have a lawsuit filed against you.
And we like that.
Yes, we do. We do. Risk management is very important. So the role of the board of directors, the board, actually, let's take a quick look at the chart that we have. That's in another one of the handouts, I believe it's the final page. There's a chart which is pretty straightforward. There's a part up in purple at the top. That's kind of the overriding concepts, I guess, basically here. The role of the board of directors: ensure that members' rights are safeguarded and proper procedures have been followed, correct wrong, minimize legal liability, ensure proper sanctions and ethics. Again, remember we had said the punishment should fit the crime. Ensure that findings of fact are sufficiently detailed in ethics. And again, that ties back to what Colette had focused on. You want to ask clarifying questions, and you want to be able to write your findings of fact that are clear and coherent, so someone who was not in the room would be able to read these independently and still understand what happened and what the basis for your decision was. So that's kind of the overriding thoughts here. The rest of the chart, basically, the green portion addresses the role of the board of directors with respect to ethics proceedings, and the yellow portion addresses the role of the board of directors with respect to arbitration. I'm not going to go through all of those, but you can see in ethics, even if there is no appeal filed, the board still would review the decision. So it really is, it is important for risk management and also for just guaranteeing that due process, or ensuring that due process was provided to the participants.
And I'll just say, do take a moment to look at this chart, because I really think it really does an excellent job of laying out the role of the board of directors in both ethics and arbitration, and what happens, what do they do, if there's no appeal, as Kathleen just said, there's still a role there. If there is an appeal by the complainant, if there's an appeal by the respondent, so all those things are kind of spelled out in a very kind of clear and organized fashion in the chart.
Right. And that might be good, I guess, if you have a new board coming in or new members on the board, right. That would be an important piece to give to them, a good resource for them just to get an overview of the entire process. All right, so let's go through this just briefly, this slide. The role of the board of directors: they're going to review grievance committee dismissals, like we had said, even if an appeal is not filed. They're going to affirm all ethics decisions. If no appeal is requested, the review is done after the time for requesting an appeal has expired. So they'll wait, obviously, to allow the party time to file an appeal if they want, and then that review would be conducted. The board will hear any appeals of ethics hearings. So if one of the parties does file an appeal, the board would hear that. The board also conducts limited procedural review for arbitration hearings. We'll talk about that in a second, but the scope of the review is more limited for arbitration than for ethics. And the board would also hear any complaints alleging a member's failure to arbitrate. Remember, that's a member's failure to arbitrate. On that chart where we had the mandatory and voluntary arbitration, remember, basically, if the respondent is a member, then they have consented to arbitrate. So that if they refuse to arbitrate, then the board would need to review that and to hear that complaint. For grievance committee appeals, the board would be there for the complainant. If the complaint or request for arbitration was dismissed, this appeal goes to the board of directors or a panel who's going to hear the case. That the appeal is going to be based on the same information that the grievance committee had available. They're not going to introduce new evidence or go out and look for additional information. It's going to be really based on the same information that the grievance committee looked at. The parties do have the ability to explain in writing why they disagree. The committee made the wrong decision because. So that would be in writing. The parties do not appear or argue their position. And then the directors would look at whatever was submitted in writing. You know, this decision was wrong because the board will look at that, consider that, and they are either going to uphold the grievance committee's decision. They're going to say, yes, that was correct, it's going to stand, or they will say they'll disagree and say, you know, the grievance committee really should not have done that, and the matter will be forwarded to professional standards at that point for a hearing. Okay, is that good?
Yes. And just so if you're, you know, kind of comparing it to what's on the chart, it would be on the green side, it would be that middle one, right? Right. Appeal of dismissal of ethics complaint. Yes. And on the arbitration side, it would be appeal of dismissal of arbitration request, kind of giving you what the summary of what that process looks like. Good, thanks.
All right, so the role for the board of directors, ethics hearing panel review. So this would be something that the grievance committee did not dismiss, right? It did move forward to the hearing panel. Someone is objecting now to what the hearing panel did. So if there is an appeal following an ethics hearing, again, that has to be in writing stating the reason. There are different bases or reasons why a party can appeal. The respondent's appeal rights would be limited to misapplying the articles of the Code of Ethics. If the panel, you know, misapplied the articles or misinterpreted the article, that would give the respondent a basis for appealing. Again, the respondent would be the one who the discipline was imposed against. So that just makes logical sense. A procedural deficiency, again, as we noted, that's kind of a prevailing theme. If there is a procedural deficiency, the right to appeal would exist. The extent of the discipline, again, we touched on that a few times. The discipline that's imposed, you know, the punishment should fit the crime. If there's a $15,000 fine imposed on an inadvertent minor offense, that would give the respondent the right to file an appeal and quite possibly prevail. The association can charge a fee for this up to $500 if they want to, for a person filing an appeal. The previous slide was about the rights, of the respondent to file an appeal. This is going to be the right, of the complainant to file an appeal. And again, this is really more limited. The complainant only has a right to file an appeal, again, for procedural deficiency, which, as we've said, that runs throughout all of these, the entire process. And the association can also charge a filing fee up to $500 for the complainant as well. So really, for the complainant, it's going to be if due process was not provided, if the procedures were not followed. Anything else to add there, Colette?
No, I think that's good.
Okay. All right, let's keep going. So ethics hearing appeals, again, what's going to happen, the chair of the ethics hearing panel, so the person who served as the chair during the hearing is going to present a summary of the case, or they can give a transcript, to the board. Here's what happened, here's the evidence, here's why this decision was made. The appellant, that's going to be the person filing the appeal, which, as we said, could be the respondent or the complainant, but they would present the argument as to why the hearing panel's decision should be overturned. This panel made the wrong decision because, and the previous two slides gave the scope of that, the complainant has a very limited right. The respondent is a little bit broader. The other party to the hearing can explain why the decision should be upheld, and then, there's going to be, basically, concept-wise, this is not a new hearing. There's not going to be any new evidence introduced. There's not going to be any cross-examination. The board is simply looking at what was decided and hearing why the party objects to it. And that really is going to be it. There's no new evidence. It's going to be an appeal. Really, it is an appeal in the legal sense of that, just reviewing what was done previously. So what's the options available to the board of directors? The board of directors has to dismiss the matter if they determine that the findings of fact do not support the hearing panel's conclusion. Basically, if they find that there was no violation of the Code of Ethics, no violation of that particular article, the matter would have to be dismissed by the board. They can modify the hearing panel's decision and the recommendation for discipline. With respect to discipline, they can only decrease the discipline. They cannot increase the discipline, right? So only decrease the discipline. And they would also have to identify in writing what their concerns were with the discipline that was originally put forth by the panel. If a procedural deficiency occurred, basically if due process was not provided, if the procedures were not followed, the rules were not followed, then the board would refer the case back to the Professional Standards Committee for a new hearing with a different hearing panel. They're not going to send it back to the same panel that made the mistake. They're really going to give both parties the benefit of, you know, a new panel hearing the evidence for the first time.
Great.
All right. And we have Board of Directors for Arbitration Appeals. All right, that everything we've said so far was for ethics. For arbitration appeals, again, just remember in general, the right to file an appeal with respect to an arbitration award is very limited. I think Colette had touched on this previously as well. You know, I lost isn't a sufficient grounds for filing an appeal, or I thought I should have, you know, received more is not a sufficient basis for an appeal. It's going to be limited. Limited procedural review, really it's only going to address whether there were procedural deficiencies or if the parties did not receive the benefit of due process. That's really it, a very limited scope of review. At the beginning of the review hearing, the chair for the arbitration panel is going to be present, and he's going to make clear that the award is not what's being considered. I'm sorry, the chair of the Board of Directors, I guess, who's the hearing, this part. They are going to make clear to the parties that it is not the award that's being considered. And that's a little bit hard for people to wrap their head around. You know, it's basically just was the process followed. So that's going to be clear. The chair has to recite that. No new evidence will be allowed. Again, this is not a hearing. This is really a review, right? Technically, it's a limited review. It's a limited review. Yes, limited.
Think about it like a limited.
Yeah. That's right. That's the way to say it. The appellant does have the opportunity to explain the bases on which he or she is requesting that the award be overturned. The appellant obviously being the one who has filed the appeal, right? So they can explain why they object to this decision, this award. The chair of the original hearing is going to respond to the allegations of the appellant, you know, the person filing the complaint, or the appeal, excuse me. So the person's going to say, I object to this award because blah, blah, blah. I did not receive the benefit of due process. The chair from the original hearing is going to respond. And again, they're presenting to the Board of Directors. So they're going to respond and explain to the Board of Directors, we did provide due process, you know, for ABC reasons. If the other party from the original hearing wants to participate, they can. They could again say, you know, the award should not be overturned because due process was awesome. We had 100% due process, no issues at all. So it should not be overturned. And again, at this point in the process, the association can charge a filing fee of up to $500. So the procedural review, basically, again, is the thing to keep in mind. It is limited. The decision of the Board of Directors, if they decide it's going to stand, if they decide it needs to go back, that's final. If the Board of Directors says it's going to stand, that's it. There's no further right of appeal to the state association or to the national association. And again, the only thing the board should be deciding is whether proper procedures were followed, whether due process was provided to the participants. If the directors find basically that their due process was not provided, if there was a substantive defect in the hearing, the award is struck, it's invalidated, and the matter goes back, again, like with ethics, it goes back to a new hearing, new panel. You're not going to send it back to the same panel that made the error the first time. So that way, I guess that's to ensure due process, and at least the second time around, the participants would receive adequate due process, and, you know, procedures will be followed. That's it? That is it. Oh, we have the appeal chart, which we've already touched on again. That's, again, I would say that is a really good resource. Again, maybe your incoming board members might want to take a look at that, and even your committee members as well, to understand what's going to be reviewed or considered if something goes wrong, if someone files a complaint or files an appeal, excuse me, what would the board look at? It's good for everyone to understand that. But I think, is that it? Are we?
Yeah, I think concluded? I think we're complete, and I think we started in the very beginning after introducing everybody and kind of letting you know what the resources are, really kind of jumping right in and due process with a due process and the elements of it. And here we are ending with due process as well. So you see that that is a critical component of this process. And the goal is to make sure at the end of the day that anybody who comes before, whether it's the Grievance Committee, the Professional Standards Committee, or the Board of Directors, has received a fair process, and the rules and you know, the rules and the manual have been followed.
That's it.
That's it.
All right. I think we have no questions, so I think we are concluded. Thank everyone for participating, and enjoy the rest of your day.
Yes, thank you all very much for your time.